Hi, Councillor Sign-Off-Gray.
Hello, Amanda.
Hello.
Please smile, Amanda.
All right. Good evening, ladies and gentlemen. I'd like to call this regular meeting of the Council of the Corporation of the Municipality of Kincardine to order at 5 o'clock on April 24th, 2024 in the Council Chambers at the Municipal Administration Centre. And roll call, we begin with Deputy Mayor Clark.
Present.
Councillor Blackwell. Councillor Kavanagh.
Present.
Councillor Hinchberger.
Present.
Councillor Kennedy.
Present.
Councillor Prenger. Councillor Steinhoff-Gray.
Present.
Councillor Stewart.
Present.
And I'd like to acknowledge the staff and public that are here in our meeting chamber tonight. Deputy Mayor Clark, please.
We'd like to begin by acknowledging that we are meeting on the traditional lands and treaty territory of the Saugeen Ojibwe Nation, which includes the Chippewas of Nawash unceded First Nation and Chippewas of Saugeen First Nation, whose ancestors were the first to inhabit, care for, and live on this land. We recognize and deeply appreciate the contributions that Indigenous peoples have made, both in caring for this land and shaping and strengthening this community, our province, and our country. As a public service organization, we are dedicated to learning and acknowledging Indigenous history and culture, and are committed to actions that move us towards a journey of truth, healing, and reconciliation with the Saugeen Ojibwe Nation, the Métis Nation of Ontario, and the historic Saugeen Métis.
Are there any amendments, additions, or deletions to or from the agenda? I have one. I'd like to need a mover and seconder. The council approved the following amendment to the agenda. An additional reason for going into closed session, a position plan, procedure, criteria, or instruction to be applied to any negotiations carried on or to be carried on by or on behalf of the municipality or local board, particularly organizational impacts of development. Mover and seconder, Councillors Inchberger and Stewart. Any discussion? All in favor? And that's carried. Disclosure of pecuniary interest. I'd like to remind any councillor to declare either now or as it arises in the meeting. And I will do so now. That is 7-1I Kincardine Ag Society Agreement, as I have a couple of children that are on the board of directors. And Deputy Mayor Clark will step in for leadership of that at the appropriate time. All right, we need a mover and seconder that the special and regular minutes of the council meeting held on April 10, 2024 be adopted as printed, moved by Councillors Kavanaugh and Deputy Mayor Clark. All in favor? That's carried. All right, matters for public participation. We have a hearing under the development charges bylaw. We need a mover and seconder that council move into the hearing under development charges bylaw meeting, and upon completion, return to council, moved by Councillors Kennedy and Steinoff Gray. All in favor? That's carried. All right, I'd like to call to order the hearing under development charges bylaw of the Council of the Corporation of the Municipality of Kincardine at 5:04 p.m. Roll call changes in that we have Councillor Prenger in attendance now. And thank you everyone for coming this evening. We are now in a development charges hearing, and council will be acting as members of a tribunal. And this is done in a different format than the regular council meeting. So in accordance with Section 9 of the Statutory Powers Procedure Act, under which we are operating this evening, this hearing is open to the public. The public are acknowledged as observers only, and the public is not allowed to speak or be disruptive at any point. And in my role as the chair, I am here to ensure decorum of the hearing and expect that the hearing proceed in a respectful manner. So pursuant to the Development Charges Act, a person who is required to pay a development charge or the person's agent may submit a formal complaint to council respecting one of only 3 issues that on which we can determine. One being the amount of the development charge, which was incorrectly determined, whether a credit is available to be used against the development charge, or the amount of the credit or the service with respect to which the credit was given or was incorrectly determined, or if there was an error in the application of the development charge bylaw. So we can only discuss and determine one of those 3 areas. Council's role will be to give the complainant and the municipal respondent an opportunity to make representation. After hearing the evidence and submission, council may either dismiss the complaint or we may rectify any incorrect determination or error that was subject of the complaint. The grounds set out in the Development Charges Act are very specific and quite focused. They do not include any request to be exempt from a development charge or a request to create a new category of development not found in the development charges bylaw. Likewise, the development charge complaint cannot be used to amend the development charges bylaw itself, alter the development charges rate, or add a credit or exemption not already within the development charges bylaw. So hearings once again are open to the public. The complainant or authorized agent will make a submission and answer questions from council and the municipality. On the other side, the municipal respondent will make a submission and answer questions from the council and complainant. And once that has happened, we allow the complainant and the municipal respondent to ask further questions based strictly on the issues that were raised as part of the questioning. And following the submission, council will deliberate and will render and declare its decision on the matter. So last week, all members of council received an unsolicited communication from the complainant. And to remedy this, the rest of council members are being supplied to all parties, or all the council members who had already received this were being provided the documents received by the complainant for the hearing. As this communication was unsolicited and sent to all members, members would not have to recuse themselves for receiving it and can still participate in the hearing. But all council members are to consider this matter based entirely on the evidence and submissions provided today. If any members of this tribunal have had any other information regarding this complainant disclosed to them, I would ask that they now disclose it. And if any members of council have had substantive discussions with either party, either the complainant or the municipality, such that they can no longer objectively consider this matter solely based on the evidence and the submissions that will be presented today, we would ask such members to consider recusing themselves of the hearing. Seeing none, we welcome Mr. Ballantyne to our hearing this evening, and the clerk will administer the oath for yourself.
Okay. Mr. Ballantyne, you can just stay right there. Do you affirm that the evidence to be given by you touching the matters in question between the parties to this proceeding shall be the truth, the whole truth, and nothing but the truth? Okay, thank you.
So I'd ask you just to press the little button in the middle there to make the light on your microphone come live. And I would ask you to make your presentation, please.
Perfect. So thank you very much for having me this evening. So my name is Mike Ballantyne. I'm the owner of 770 Queen Street in Kincardine. It's a mixed-use commercial building. I'd like to begin by making a brief apology for the material that was sent out. I was unaware of the processes that were supposed to be in place, obviously, with respect to that, and thought that I was providing a briefing of information, but obviously was supposed to have gone a different route in terms of disseminating that information, so I do apologize for that. In brief, the reason that I have come to this point in terms of making this presentation is that, as was mentioned, under the 3 clauses that can be appealed with respect to the Development Charges Act, or bylaw, pardon me, I do think that the development bylaw was applied incorrectly during the course of the application for a building permit for renovation at 770 Queen Street. Essentially, in January of this year, I reached out to the building department with plans to renovate an upstairs component of my building and turn what was a just under 400 square foot commercial space into an additional 1-bedroom apartment. And so I began the process of obtaining a building permit to complete this. That was in early January. The process, of course, takes some time. And so over the course of the next number of weeks, there was some conversations back and forth between myself and members from the building department. And it was asked that I get a new set of drawings completed by a qualified individual, which I had completed through DARCAD drafting. I had a set of previous drawings from when I had done the original renovations on the building approximately 4 years earlier. And they requested a new set, which were obtained, showing the proposed changes, which essentially amounted to the removal of a wall, interior wall, and the addition of a kitchen unit to be able to turn it into a rental unit. The building itself is already mixed use. There's a commercial component on the main level, and then the upper level is a 1-bedroom apartment on the west side, and was currently commercial space, currently being renovated into an additional apartment there. After the initial drawings had been submitted, there was a bit of back and forth with some questions, and then on February 22nd, I had emailed to confirm where things were with respect to the permit. And so the cost for the updated drawings was $1,017. On February 22nd, I received word in an email from the building department that they had spoken to Dwayne, the chief building official, and that he was good to sign off on this permit. And I had inquired with that as I was in the process of waiting to receive confirmation that the permit was approved so that I could place the deposit on some of the materials required for the renovation itself. So after I received that email, I had made a non-refundable deposit then in the amount of $3,710.92 for construction materials and cabinetry for the renovation. Then on February 28th, I received the email that the permit had been issued, and I also paid, $476.30 in payment for the permit. It was only after the permit had been issued and I had made those deposits on February 29th that I received an email communication from the chief building official in which he indicated that after having reviewed it, that it was felt that a development charge applied to this project. And I was then asked to make an additional payment for $9,425.50 for the development charge. In all of the time from the early January through until the February 29th, there had been no mention from the building department about any potential application of development charge for this project. The development charges, of course, are fairly complex, and as I've learned from having read through the Development Charges Act from Ontario, is pretty complex. It's particularly not easy for a non-lawyer to digest. In fact, in my conversations with Dwayne, he indicated that it was confusing enough that he had to seek out confirmation from a development charges consultant to determine whether or not a development charge applied to my project. And if a chief building official who has a number of years of experience is unable to determine whether a development charge is applied, I think it's fair to assume that it would be challenging for me to be able to determine that as well. But after the development charge email came through, I responded and I spoke with Dwayne and was inquiring about why this hadn't been brought to my attention earlier in the process. And he did apologize and said that this was an oversight and that it was something that they had missed during the process of their review of the permit. And so I do believe that the area in which the development charge bylaw was inappropriately enacted was that the development charge bylaw states that the development charge is supposed to be calculated on the date that the permit is issued and is supposed to be made aware prior to that. And the permit's not supposed to be issued until the payment for any existing development charge has been paid. But of course, I wasn't even made aware of the possibility of development charge until after the permit had already been issued. With the total renovation cost estimated for the actual apartment renovation of between $18,000 and $20,000, I certainly would not have proceeded with that project if I had thought that a development charge would represent 50% of the total budget for the project itself. However, at that point, I've already now spent $5,204 in updated drawings, permit fees, and deposits for construction materials. So I'm left in a challenging position of determining whether to just write off the $5,200 that I've spent or continue on with the project. And I think that it would have been, had I known about the permit cost or the development charge cost, pardon me, prior to beginning this process, I certainly wouldn't have continued forward. I would have simply rented it out or leased it as a commercial space and left it as is. And so I think I'll hold there at this point in time. Thank you.
Thank you, Mr. Ballantyne. Once again, if you just turn off your microphone, it just interferes with the mics. So I'll afford the municipal representatives, Dwayne McNabb, our CBO, and David Woodward, our municipal solicitor, to direct any questions towards Mr. Ballantyne at this time. Yes. Council will get opportunity following theirs. So.
Thank you very much, Mr. Mayor. And through
We'll
you,
just wait till Mr. Ballantyne's back at his
Sure,
table
okay.
again, please.
Excuse me. Yeah.
Mr. Woodward, please.
Thank you, Mr. Mayor, and through you, your lordship. I have just a few questions for Dr. Ballantyne arising from his presentation. Dr. Ballantyne, my understanding is that the work completed or proposed, I should say, for this unit, that is to convert the unit from what was prior a commercial use. Is that correct?
Yes, that's correct.
Okay. And it would be a residential use going forward?
Correct. The upper level was currently split between a residential unit on the one side and then commercial space on the front side.
Okay. And I'd just like you to describe the work. You mentioned that there's the movement of a wall. Is that correct?
So there initially was not to be a removal of a wall. That has actually only come to be since it was requested through the building department in the course of review of the permit. So we had planned to initially leave the wall in place, but that had since been requested to be removed because it was felt that it didn't meet an adequate size for a sleeping space.
And there's kitchen cabinetry as well,
Correct.
and cooking facilities
Correct.
installed as well. Other kitchen.
Not sorry, they haven't been installed yet, but
Oh,
I
no,
plan
I'm
to be
I'm
great,
just
yes.
saying
Yeah.
as part of the proposed project.
Yeah.
Just for clarity, this is like a tribunal, so the conversation doesn't go back and forth between that way.
Oh, I'm
It
sorry.
comes this way and then goes back to you. So we'll maintain that format, please, gentlemen.
apologies.
My apologies. The property currently, is it a commercial zone, a C1 commercial zone, Mr. Mayor?
Yes, so yes, it is at C1. Yeah.
And on the main floor of the property, what is it currently used for?
It's a medical clinic.
And the name of that clinic is Queen Street Medical Clinic, correct?
Correct.
And that's a commercial use on the main floor area. Are we in agreement?
Correct.
You would agree with that? Okay. And there are only the two residential units, or I should say, there are only the two units on the second floor, correct?
Within the confines of the building that I own, that's correct. There is an easement for the common stairway and hallway upstairs, which adjoins to the building directly to the north. And there's additional residential units from that building. We share a common space that's owned as part of my building, but it's the same access point.
You mentioned that you were not informed about the development charges until after the permit was issued. How long after the permit was issued and picked up how long was it until you found out about, how long was it until it was discovered that the development charges applied?
So I received word that the permit was to be approved on February 22nd. February 28th, I received the email through the cloud permit system, which issued the permit online. And then it was February 29th that I received the email with the first mention of the development charge.
So one day after pickup, I believe. I just wanted to make just a few comments, and I don't know if their presentation could come up in a moment. Okay. I'm going to go to this just for a moment and speak through, present to council, your lordship.
Dr. Ballantyne, could you turn off your microphone?
I wanted to point out one thing for council, just to assist them in their review and to assist all parties in their review. There are two sets of development charges that are administered by Kincardine. One is under Kincardine Development Charges bylaw. And the municipality of Kincardine also administers Bruce County's development charges, but those development charges are actually imposed under a separate bylaw. So the legislation is very clear that the development charges, the municipality that imposes the development charge must hear the appeal. So the scope of this hearing is actually only related to Kincardine's development charges, not Bruce County's. Bruce County, if Dr. Ballantyne wished to appeal that, that's beyond the scope of the hearing today. Okay, I just wanted to make that clear to councilors that the decision today will only apply with respect to the municipality of Concardin's development charges bylaw and not to the development charges in full. I just for your information, Your Lordship, thank you for your introduction in terms of the hearing, in terms of the scope of the hearing and the criteria for consideration when making a decision. Today, council is the judge. It's a different role than council normally has. As elected officials, you usually make the rules and pass the bylaws. And today, you apply the pre-existing bylaw. It's not for you to create an exemption in this situation, of course, or alter the rate or add a credit that's not there. And also, you must focus solely on the information presented today. I just want to then turn things over briefly to Dwayne so he can provide some factual information. And I'm not sure the only thing I wanted to just request, Your Lordship, do you want me sworn in as well? Because I'm happy to do that, of course.
It would be appropriate for both yourself and Mr. McNabb to have done that.
Okay.
After, go ahead, swear him in first, and then we'll have that comment.
So David M. Woodward, do you affirm that the evidence to be given by you touching the matters in question between the parties to this proceeding shall be the truth, the whole truth, and nothing but the truth?
I do.
Council members, are there any questions that you would want to direct specifically to
Mr. Woodward.
Are there, actually, I'm going to change that question. We have another municipal representative. Do you have any questions? Actually, we need to swear Dwayne in first before he says anything, so we're going to do that.
Dwayne McNabb, do you affirm that the evidence to be given by you touching the matters in question between the parties to this proceeding shall be the truth, the whole truth, and nothing but the truth?
I do.
Mr. McNabb, thank you for being here this evening. Do you have any specific questions that you would like to direct towards Mr. Ballantyne? Not a statement or a comment, but questions, please.
Fair enough. Thank you through your mayor. I'd just like to actually go through statement of facts and just to go over what I have in front of me here. And it accurately portrays what Mr. Ballantyne's already went through. But I just want to go through in a bit more detail if that's okay.
No.
Okay.
So thank you for that. We will get to it, but I'm going to afford our council members opportunity to ask a question. I'm sure that one of those questions will be, do you have any other additional information that you need to give to us? And at which point there would be a statement, but I'm going to afford council the direction where we go from here. Correct. So at this point, we have questions that are directed specifically to Mr. Ballantyne. Our municipal representatives had opportunity to ask their questions, so now it is questions of council directed towards Mr. Ballantyne. So Councillor Hinchberger, please.
Thank you, through you, Mayor. So, Mr. Ballantyne, it's correct that you're claiming that the development charges bylaw was misapplied by virtue of when the building permit costs were calculated. Is that correct?
That's correct. To the best of my understanding, in the bylaw, it's supposed to be calculated the date that the permit is issued.
Okay, thank you. So the follow-up would be is, regardless of when it was calculated or not calculated, would the amount of the charges or be any different if it had been calculated on what you considered would have been the correct date?
Sorry, can I just clarify? Sorry, are you asking if I think that the amount would have varied? No, I don't believe that that would have varied.
Counselor Stewart, please.
Through you, I'm not quite sure this is a question for Mr. Valentine. It might be a question for Mr. McNabb. I'm not quite sure when you start talking about King Cardin and County of Bruce, and then you talk about a charge of $9,986.21. Could someone break that down for us between King Cardin and the County of Bruce, please? I'm not sure if that's a Mr. Valentine, but he might know the answer. Thank you.
Mr. McNabb, can you provide those? Oh, I'm
Oh,
sorry.
sorry, I do
Mr.
have-
Valentine, if you have the numbers.
I
there,
have the
perfect.
breakdown, and Mr. McNabb is welcome to correct me if I'm incorrect, but the municipal development charge was $13,023.56, less a credit from commercial space of $4,464.98, resulting in the total municipal development charge of $8,558.58. And the county development charge was $866.92, bringing the total development charge to $9,425.50.
Thank you very much.
Further questions from council members? Councillor Prenger?
Thank you, through your chair. I was just trying to formulate in my head how I want to say this. Dr. Valentine, I think I'm trying to figure out how to say it instead of as a question rather than a statement getting clarification. But it sounds like, as Councillor Hinchberger sort of alluded to, that the problem isn't, and then your answer made it sound this way, the problem isn't the amount necessarily, that the amount changed or that it was different than what you were, sorry, it is different than what you were expecting because you weren't expecting anything because you weren't aware of it. Is that the problem is that you were not informed of it at the time of the permit being issued, therefore you were not able to make a decision based on knowing that number before you paid for and accepted the permit. Can you please clarify if that's a correct understanding or not?
That's correct. In essence, at the beginning of the project, if I had been made aware that the development charge would apply to this type of a project, I would have obviously inquired as to what the amount of the development charge would have been. And if I'd been provided with an answer of $9,425, I would not have proceeded with the project.
Councillor Stanoff Gray, please.
Thank you, through your chair. I just want to clarify, am I allowed to ask Dwayne a question or is this only questions for Dr. Valentine?
I'm going to ask our CBO for his report. So if you would wait till he's done for that presentation, Councillor, please.
Thank you.
All right, if there are no further questions from council, I'd ask our CBO to make his presentation, please.
Thank you, Mayor. To go through my report here, I'd just like to start by initially when the permit was received, it was reviewed for the application, which was for renovation. And I think Mike's explained this pretty clearly. The renovation was to convert a second floor and commercial space into a residential single bedroom bachelor apartment. And so we checked that through the zoning, which C1 permits that type of use. And that under the C1 use, that building in question, the C1 use was a mixed use occupancy, which is commercial on the main floor, residential on the second floor. And the conversion to have a residential use on the second floor for bachelor apartment is also permitted within the C1. It's permitted to be on the main floor, on the main floor behind the commercial use or on the second floor. So it met all the criteria from the zoning standpoint. Further, it was reviewed through the building code to address any issues for compliance with the building code design itself. And that's where Mike had mentioned that the plans were reviewed and vetted, and there's a few changes. Some of them, if you do note, in the design, it's 385 square meters. It's small, there's no question. And it was on some aspects, it was close to the minimum floor areas in the building code. However, dealing with the plans that Mr. Valentine provided, I think through DARCAD, I think they demonstrated we had moved a couple things for combined living spaces and met the minimum floor areas. So within that, there were kitchen works, there was addition of, I do believe, a sink, and there'd be some kitchen cabinetry, some washrooms, laundry facilities, stuff like that. It all went into this design, including some, I think, baseboard heating, I think, is what we're looking at putting in, or it might already be there. I'm not sure, Mike. There was just some notes on DARCAD's plans that just highlighted some of the works that would be done on the project. So in doing that, then we went through our stages of cloud permit, which I do believe Michael had submitted everything through cloud permit. And during that review there, we assign a fee. And I think Mike has detailed very well, is the building permit fee itself on the initial review was $476. And I'm not sure if that was in 30 cents. So either way, we did assess that, and we initially looked at the development charge aspect, and it was through the bylaw. And I do concur with Michael, the bylaw is somewhat difficult if you're going through it. It takes a little bit of reading and rereading, but when we initially looked through it, we're looking at section 6 and 6.1 in the development charges bylaw does identify an exemption for a residential, sorry, Dave, oh, I can hear it. It does provide for an exemption to a development charge for the creation of one additional dwelling unit in any other existing residential building, provided the gross floor area does not exceed that of the smallest dwelling unit already within the building. And some of the components there within any other existing residential building, looking at this, yes, it is a residential building, but it's not a residential building. It's a commercial building with a residential component. So there's some details there that we went through, and that's where, when it was initially assigned, there was no DCs gone through or looked at. Upon that, once we initiated that permit bill for Mr. Valentine, in checking through our development charges, we went back through, the county has a DC calculator, and tracking that, we're looking for our exemptions, and there wasn't a clear exemption, which forced staff to go back and look at this development charge application again and see what fees, why we're not aligning exactly with the drop-down menu on the county's DC. In doing that, that's where we moved on to section 11 of the Development Charges Act. And it aligns a little bit better with what we're doing because it speaks to the conversion of a commercial space to a residential and allows a credit. So in doing that, we reviewed the conversion components of the DC bylaw and determined that a DC was applicable. However, a credit would be afforded. In staff's review of this, we wanted to be for sure because well aware that we'd already assigned Mr. Valentine a permit fee, and now going back to say that the permit itself would be considered issued in air because there's outstanding development charges. Hence where I know Mr. Valentine would say that we've heard the revocation of a building permit. It does open the door that there's fees that are technically outstanding if they're applicable. So that's where we contacted our development charges consultant and reviewed this very carefully to see, does this actually apply and are we reading this correctly? And it was determined that the application under section 11 was appropriate for this type of development as it was a conversion of a commercial use to a residential use. And he did reinforce there was a credit available. So in doing that, that's when we reassessed and reapplied the development charges to an initial permit bill, which was sent to Mr. Valentine. In addition, that's about where we're at today is how we arrived at the development charges applicability. And that was through going through our consultant as well as some opinions from our lawyer on the applicability. So I don't have anything further to add to that side of the presentation if council has any questions.
Actually, wait till you finish.
That's right.
Mr. Valentine, do you have any questions to direct to our chief building official? Dwayne, your microphone, please.
Thank you. Can I just confirm if, from my reading of the bylaw, if it's correct that if I was to, for example, be applying to start a new subdivision, which would of course require significant investment through the town for infrastructure, the development charges would be calculated prior to the permit for that being completed. Is that correct?
So if you were doing a subdivision, in your subdivision bylaw, subdivision agreement, there would be a clause there that would indicate that you'd be subject to paying all development charges as applicable to the current bylaw. At the time of application for your building permit, that would be reviewed and the appropriate development charge would be assigned. They're not payable until permit is part of the issuance of that permit. That's when those fees would be due.
Mr. Valentine, anything else?
Yeah, so I understand that the payments would not be collected until the charges were due, but I'd just like to ask why it is that I wasn't made aware of what the development charge would be until after the permit was issued, if it's supposed to be made aware of prior to permits being issued.
Yes. You would have been made aware of the development charges if they had been caught. That's exactly where we're at, is the review of the development charges bylaw. And the sections that I quoted, that's how it was reviewed by myself in the development charges review. So it was not caught, and that's why it would have not been presented to Mr. Ballantyne.
Anything else? Councillor Stanoff Gray, you had a question for our CBO?
Yes, thank you, through you, Chair. It's kind of a two-parter, but I guess my question through you for Dwayne would be, how often do we have these situations? I guess what I'm trying to understand is, would you not be confident when you're assigning a permit fee? I'm a little miffed when we say that we were unsure about what should be applied and we retroactively did it before assigning that permit. So how often does this happen?
I'm sorry, that question doesn't have much bearing or relevance in this
Well,
hearing.
I guess what I'm trying to understand, though, is what the level of understanding is expected in layman terms. Because if we do the proper application process and we expect certain inputs, I'd like to understand what our accountability is to ensure understanding, is where I'm going with this.
So what, correct me if I'm wrong, Councillor Stanoff Gray, but the question I heard you ask is it our job to understand the DC charges, or is it the applicant's job?
Well, I think
that
that is what I'm asking. That is correct. That is a better representation of it. Because I'm confused why we asked for advice after we issued it. I'm just trying to understand the operation of events is all. I'm confused.
Ultimately, is it the applicant or the municipality that is responsible for understanding and interpreting our development charge bylaw?
Yes, particularly because what I'm trying to understand is what provokes a second opinion when we already gave a rendering of what our understanding was at the time that we issued the permit. I'm trying to understand the order of operations where the confusion came in.
CBO, please.
Thank you. Yes, the development charges bylaw is administered in-house. Is definitely the responsibility of the municipality, as well as the applicant, to know the bylaws of the municipality. But yes, the bylaw is administered in-house, typically through my department and Treasury Department. Mine particularly on collecting the fees at the time of permit issuance. So yes, I would be the one reviewing that. It's definitely one of those bylaws that we review to ensure that we do have all our fees captured at the time of permit issuance.
Other council members with questions? Deputy Mayor, please.
Thank you, Mayor, through you. Mr. McNabb, can I just perhaps understand if we go back to section 6 of the bylaw? Is it correct that you believed this matter fell within one of the exceptions, particularly that of the enlargement of the residential unit?
Through your Mayor, yes, Counselor, I did look through that, and that was my initial review, was going through that sentence in the DC Act, or the DC bylaw. When I read through it, that's how I figured we applied the DC in this case.
Can you perhaps just lay some foundation? What gave rise to you believing that that was the reason that it fell within an exception?
Through your Mayor, honestly, with the changes in the Development Charges Act that we've seen over the last course of the year through Bill 23, the addition of single 1 and 2 unit apartment buildings, especially being the size of it, being it smaller than anything that existed in the building currently, it honestly was a trigger that, okay, that's the exemption, and that was applied to it.
And was that information conveyed to Dr. Ballantyne?
Yes, it was in an email. I had talked to him on the phone as well and explained to him that this is a section that I had reviewed, and unfortunately, when we looked at it, that it was incorrect.
Sorry, let me rephrase that. Was the information conveyed to Dr. Ballantyne that you believed it fell within an exception?
Oh, let me check through my notes here. I don't have my notes right in front of me, but I know that I had relayed to Mr. Ballantyne that we had made an error in the application of DCs, but I don't have that in front of me. Specifically on the section, sorry.
No, perhaps I'll rephrase again. Uh, When you believed it was an exception, and as such, the DC charges didn't apply, was that conveyed to Dr. Ballantyne?
I don't have my email in front of me. I do have reference to that in an email, but I have to refer back to it to ensure exactly what it was saying.
What date was the permit issued?
I think it was February 28th. Just bear with me. There was a date for the permit. Dated. February 28th, 2024.
So would it be fair that at that stage, you were still of the belief that the exception applied?
As of February 28th?
That's correct.
Yes. Yes, that date was, oh, sorry. That's a good question.
No, that's fine. And when was Dr. Ballantyne notified that the exception no longer applied because of an error on the part of the municipality?
So through you, Mayor. So the permit was issued because I was reviewing it through Cloud Permit. I remember completing the process to go through, confirm the bill, send that through and issue the permit. And it was, I do believe the following day is a Friday. I do believe I called Mr. Ballantyne to inform him that there was an error.
Sorry, and if you could just jog my recollection on this, how long had that process been going on from the point of working with Dr. Ballantyne to the issuance of the permit February 28th?
Through you, Mayor, within a day.
No. I meant the process of working with Dr. Ballantyne initially. How many months was that going on?
I can go through and I have an application date received in January on through Cloud Permit. I know staff would have dealt with him back and forth on submission requirements and review. It would have came to my desk. Obviously was closer to the February 28th date. One of the final reviewing steps for the permit issuance.
So would that have been January 2024, are you saying the application? Okay,
That's correct.
I have no further questions.
Thank you, Counselor, and I'm spelling that a different way than normal, so, Counselor Stewart, please.
Thank you. I'm not quite sure if this is a question that can be asked, and I'll ask you, Mayor, whether it needs to be. This is a question for, Dwayne. If, things are changing so fast at the provincial level with Bill 23 and Bill 109 and everything. If, Dr. Valentine came and offered this as an affordable rental unit, I believe development charges would disappear. Is that correct?
So I'm gonna suggest that that's a little outside the scope. The question that Dr. Ballantyne is asking is about the timelines for the particular application of the development charges in relation to the issuance of the building permit.
Fully accept that.
Councillor Hinchberger, please.
Actually, thank you, through you, Mayor. Before I ask my question, based on what you just said, I'm a little confused. So even though Dr. Ballantyne is claiming that the development charges bylaw was incorrectly applied when it comes to when it was actually calculated, that prohibits us from exploring if the development charges bylaw was incorrectly applied elsewhere?
The short answer is no.
Okay.
But the previous question about the purpose was a little beyond the scope of what we're talking about.
Thank you. So I'm going to follow up a bit on Deputy Mayor Clark. And I want to focus on the rules with respect to exemptions for intensification of existing housing, specifically paragraph 61C. So it's the creation of one additional dwelling unit in any other existing residential building, provided the gross floor area of the additional unit does not exceed the smallest existing dwelling unit already in the building. And I think we've already established that the proposed addition is smaller than the existing residential dwelling that's on the second floor on the east side. Is that correct?
Yeah, directed at you,
Yes, it is.
CBO.
Okay, so my follow-up would be is, an institutional building is defined in the development charges bylaw. A residential building is not. A building is defined and a residential use is defined. And under the residential uses, I'll get there. Under the residential uses, it includes buildings or portions thereof designed or intended for use as a home or a residence, and it can include, among other things, the residential portion of a mixed-use building. So I guess my question is, for the purposes of this bylaw, is this building not a residential building?
So I choose not to muddy the waters, but the zoning down there is not R1, it is commercial, is it not? So I'm not sure whether the councillor's question was talking about R1 or about the ability to have residential within a C.
Sorry, I wasn't getting into the business of zoning and the zoning bylaw at all. I'm limiting myself specifically to our development charges bylaw.
Answer, or do you want the question again?
No, thank you, Mayor, and to you, Mr. Inchberger, yes, you're right. There is no definition of a residential or existing like a residential building. It's not defined in the Development Charges Act how a residential use is. So this building, being that it's mixed use, as residential as well as commercial, which the reference to muddying the waters, yes, it does get muddy. When we're looking at strictly from a zoning perspective, this is a commercial building. It's zone C1. However, within zoning, there's mixed use commercial. And through our official plans, there's mixed use uses which residential is a permitted use. So again, I'm not sure if I'm answering the question correctly, but when you refer to 61C, there is portions of that that are, in my mind, applicable to this scenario. However, through the development charges consultant, there's a more applicable section.
Thank you for the answer.
Directed towards you, does our development charge bylaw speak specifically to the timing of the issuance of the development charge fees?
Yes, it references the development charges shall be paid prior to the issuance of the first building permit.
Further questions from council members? Councillor Prenger, please.
Thank you, through your chair. Can the CBO just clarify what the more applicable section is than 61C, please?
Thank you, Councilor Brown. I'll do my best. If you look at the rules with respect to exemptions for intensification of existing housing, 61C is the first reference in my report. If you go to section 11, this is respect to redevelopment. And you got to read through redevelopment because initially it won't trigger you that this is a redevelopment. This is more like a renovation, a conversion. If you read through 11.2 of the Development Charges Act, if a development or redevelopment involves a demolition and replacement of a building or structure, and then it says, or the conversion from one principal use to another, a credit shall be allowed. The principal use being commercial, going to another use being residential, would suit this clause correctly from what we've been provided from our consultants and reviews. So that would be the clause that applies to this one, where that's where the conversion calculation was done, that afforded a credit to Mr. Ballantyne's project for the size of the commercial space being 385 square meters. We calculate that against the commercial component, and the credit is put against the residential component. I don't know if that's a quick and dirty way how to answer that question, but that's how the calculation works out. But that's through reading through the Development Charges Act. That's how we get to that section.
All right, at this point, we have opportunity for both the complainant and the respondent to ask questions that or make a statement, not to repeat what you've already said, but in response to any of the comments that you have heard previously. You have opportunity, Mr. Ballantyne, to summarize any responses to Mr. McNabb or Mr. Woodward's comments, okay?
Thank you very much. A few quick points to the question that was asked by Deputy Mayor Clark. I was not made aware of a possible exemption being found under the Development Charges Act because I was not made aware of any potential development charge issue whatsoever until the day after the permit was issued. There was no mention of development charges from the beginning stage of early January through until the day after the permit was issued. So I did not realize that they were looking at it as a possible exception because I wasn't aware that it was being considered for application. I think just for the record, I'd just like to clarify, Mr. McNabb was saying it's 358 square meters. It's actually 35.8 square meters for the development or redevelopment, pardon me. And then finally, I think just the number of questions with respect to the exemptions that are found within the bylaw and the difficulty that's being expressed by Mr. McNabb in terms of interpreting this. And as Councillor Hinchberger pointed out, the fact that there's no specific definition for residential or dwelling unit, pardon me. When I had the first conversation with Mr. McNabb about this on February 29th, the first thing I did obviously was to read through the development charges bylaw at that point in time. And I would just again state, I think that there was significant difficulty on the part of the chief building official for the municipality to understand and interpret the development bylaw. And so I don't think it's a stretch to consider that it would be difficult, if not impossible, for me to be able to interpret whether or not development charges apply to the particular project that I was considering. And certainly, had I thought that that was a possibility, I would have inquired about it before, but the wording is quite vague. But I think in general, it's, again, just that I was not made aware until after the fact. But that's, I think, all I have to say. Thank you very much.
Thank you, Mr. Ballantyne. Now we have opportunity for Mr. Woodward or Mr. McNabb to make a statement in regards to, not to your previous statements, but to what you have heard from questions or Mr. Ballantyne. Mr. Woodward, please.
Thank you, and through you, Mr. Mayor. I think it would be helpful if I went through the development charge bylaw and just went through the it for council to assist you in interpreting the development charges bylaw, and also provide some background with respect to that. Now, Mr. Mayor, when I first spoke, I just wanted to ask a few questions to Dr. Ballantyne, and also just present Wayne. I did want to go through these submissions, and these are legal submissions which have arisen as a result of the questions of council and Chief Building Official McNabb's presentation. So I just draw your attention to the screen. Just past that one. The first thing I'd like to point out is the definition of development. And the definition of development, it's pretty clear that when a development occurs, when one of the actions referred to in Section 7 of the bylaw occurs. And one of those actions is the issuance of a building permit. Section 5, it talks about that there's no exemptions to any lands within the municipality to development charges bylaws. But Section 7, and then Section 7 goes on, development charges shall be calculated and collected in accordance with the provisions of this bylaw and imposed on land developed for residential and non-residential use where the development requires, and one is the issuing of a building permit. That doesn't speak to timing, and the timing of the charge is not vitiated because one day after the permit, something was caught. In this situation, Bruce County's screening process caught the development charge as being missed. That's unfortunate, but nonetheless, that doesn't vitiate the applicability of the charge. The charge still applies under Section 7, okay? And then we move on to the exemptions. And despite Section 5 above, which of course talks about all the lands in the municipality subject to development charges, there are these exemptions, which you've identified quite correctly. The first exemption, 6.1a, doesn't apply because it's not the enlargement of an existing residential dwelling unit. This is actually the creation of a new one. The second exemption doesn't apply because it's the creation of one or two additional residential dwelling units in an existing single detached dwelling. Okay, this is not a single detached dwelling. This is actually a commercial building. Zone C1. It is surrounded by commercial uses. It does, like all Ontario towns, in the upper floors, have a mixed use that's secondary to that primary commercial use. So Section B doesn't apply. It's definitely not a single detached dwelling. The closer one, and the question for council, I believe, is 6.1c. And this is what caused confusion at the time the decision was initially made not to apply the development charge. It says the creation of one additional unit, that applies, in any other existing residential building. That's the question, whether this is a residential building, because the gross floor area of this additional unit does not exceed the smallest existing dwelling unit. I drove in today. I drove in from Highway 21. I went down to Queen Street because it said, there was a sign that said business area, and I drove down Queen Street. I'm surrounded by businesses. I drive by this building, Queen Street Medical Clinic. It's surrounded by businesses everywhere. This is the downtown core of Kincardine. This is a commercial building. This is not an existing residential building. If this is an existing residential building, then suddenly all downtown cores are residential. In commercial, in the C1 zone, you do have residential uses permitted. And I'll get to that in a minute. But you do not have a situation here where this is simply a residential building. It's a commercial building. And that's why the development consultant, and that's why Bruce County caught it. And unfortunately, it wasn't caught until a day later. But, you know, these are difficult questions because a lot of these things are changing by the day. So these are difficult questions for municipal staff to catch every time. But nonetheless, residential building, that's what it applies to. So let's move forward. Section 11. This is the credit that's been applied in this case. Since it is a conversion, 11.1, or I should say 11.2, allows the credit to have been applied, and it was applied in this place, in this particular situation, quite correctly. Okay. How much was that credit? The credit is almost a third of the cost. It's effectively $4,400 of a development charge fee that is well over 13. So this is a fairly significant reduction. I'm walking you through the bylaw, but I'm also trying to explain to you something else. I want you to understand that this is the fair application of these development charges. This is a specific reduction for the conversion to the dwelling unit. It's by the letter. For these C1 commercial zones, for these commercial buildings, right in your downtown core, it's not a residential building. It is a building where it is surrounded and primarily commercial. And that's why this development charge applies. Now, to give you some comfort, to make you fully understand that this is a very fair application, I want to go behind your development charges bylaw, and I want to talk about the enabling legislation. So the enabling legislation, sorry, I didn't move to section 3. Here we are. This is the Development Charges Act. The definition of development under the Development Charges Act is much wider than your bylaw. So Kincardine has the ability to impose development charges on many more projects and much wider on a much wider scope, but it chose not to under its 2021 development charges bylaw. The 2021 development charges bylaw has a narrow definition of development, and it has the exemptions, and it has the credits that are available and are applied on a regular basis, making it very fair and encouraging development. Again, Development Charges Act, I'm going to go through section 2. It mirrors our development charges bylaw in terms of when it applies. Okay. But again, the definition of development is much narrower. So this is a you know, a very fair bylaw and something that encourages development. The other piece I would The other information I would like to give council is there have been some additional applications for this property in the past. Some of them predate the 2021 development charges bylaw. Those those applications related to renovation of an office and also to sorry, I've just drawn a blank, but one of them was renovation of an office. And that would be this unit. So this unit was commercial and the main floor has always been commercial. Okay? A 2021 application, which I believe was by Mr. or Dr. Valentine, was for the improvement of the bedroom, or the dwelling unit, and on the first floor. Now, I have a copy of that, and I can make it an exhibit, and we can circulate it. But that application was unclear as to what the prior use was, but staff did not apply the development charge in that particular case because it wasn't clear what the prior use is, but ultimately the improvements made it available to rent. So my point being, this isn't a situation where this development charges bylaw is applied ad hoc or is unfairly applied. This is a very, the development charge bylaw itself has limited scope to what Kincardine could apply. And it hasn't applied the development charges aggressively in the past because the 2021 application may well have been something where development charges should have been applied. I'm trying to make it clear to you that notwithstanding the fact that the development charges were raised a day late, this is not a situation where the development charges are unfairly applied. Okay. Just to, we don't have much guidance in terms of residential buildings. So I did, just for council's deliberations, looked in your zoning bylaw, and I just wanted to provide some information for you. Oops, wrong number. Okay.
Mr. Woodward, this is really outside the scope of what you had heard regarding questions from council or Dr. Ballantyne. So I would ask you to be very concise with this part of the presentation, please.
All right, I'll stop there then, because I won't go into the zoning bylaw, but the zoning area, I'll stop there then if you feel I'm outside my scope. Thank you very much.
All right, as per the format, committee will now deliberate, and it is council's choice whether you would like to be in closed session to do that, or whether you would are comfortable deliberating in open session. I'd need a recommendation from one of the councillors. Dr. Ballantyne, please.
Sorry, I'm just wondering if I might ask, given that that was significant new information that was presented rather than a response to the previous information, may I be afforded an opportunity for a quick response?
You may.
Thank you. I would just like to point out that with respect to Mr. Woodward, my appeal is expressly not based on whether or not development charges apply to this particular project. It's based on whether the bylaw was followed and whether I was made aware of those development charges prior. Thank you.
Thank you. It's concise. Thank you. Councillor Hinchberger, Councillor Stewart, Pranger, Deputy Mayor, what are you thinking?
I'd ask that we deliberate and closed.
Okay. Any opposition to that? All right, we will retire to the Gord Gerald Boardroom. I believe it is prepared to connect to Zoom with our fellow councillors. So we will adjourn briefly, and we'll be back with a decision with reasons.
Counselor Senoff Gray and Counselor Kennedy, I'll send you a link for that, okay?
Thank you very much.